Hi, everyone. Louisiana Succession Attorney Brad Scott here. Today, I want to talk to you about the role of an administrator or an executor in a succession and how that works. A lot of times, you might see where there's a last will and testament and somebody's been named as the executor, or they've gone to court and they've been appointed as the administrator over the estate. So, what is that about, and what's their role, what's their responsibilities, and how do we do this? Well, let's start first by talking about how the person gets appointed as an administrator. Like I mentioned before, they could be named in a will as an executor. An executor and administrator, basically the same thing. And in that process, you'd have to get the will probated, and you'd ask the court to recognize you as the executor over the estate. That usually requires you signing some type of oath of office, agreeing that you're going to do everything legally and fairly on behalf of the estate and represent the estate in a good manner. There's sometimes necessary that you post a bond, which is there just in case you were to mess things up or you were to steal any assets. That gives the heirs some type of way to get repaid for your errors, if there are any. Once you take the oath and you appoint and post the bond, if one is necessary, then the court is going to issue something called letters of administration. And this is basically the document from the court that gives you the power to transact on behalf of the estate. It's kind of like a power of attorney from the court. It recognizes that you have been appointed and tells people that you're going to be dealing with that you're in charge of the estate. Using those letters of administration and those powers, you can then transact on assets. You can close bank accounts, you can pay bills, you can sell property. There's various things you can do with that. Your job as the administrator, your role is to deal with the estate assets and liabilities, get all that taken care of, and then get that estate closed and the assets passed on to the heirs. You're in charge of these things. You have a duty to take care of these things in a very quick and efficient manner. If you don't do your job correctly, someone can always come in and ask for you to be removed. Once you're finished administering the estate, it's your job, once you've delivered all these things to the heirs, to close out that estate. And on the back end, what you need to do is you file an accounting to show everything that you did, what assets the estate started with, things that you may have sold or disposed of, and what's remaining in the estate to be distributed to the heirs. You're going to file that with the court. You're going to get that approved, assuming no one files any oppositions. The court will then discharge you as the administrator, and the succession will be complete. It's a fairly straightforward process, but it gives some type of order to who is in charge. Unfortunately, if we didn't have that situation, you had multiple people involved, multiple kids, you'd have everybody trying to get things done, and it would be a little bit of a chaotic situation. So we have a procedure, and we have a set of rules that we follow, and a system for taking care of estates in a very orderly fashion. If you have any more questions about administration of estates or any other estate matters, reach out to us. We'd love to help you. If we can't help you, we'll try to point you in the right direction to get the answers that you need. Until next time, thank you for watching.